So, ladies and gentlemen, we have with us Matthew J. Nedumpara, senior advocate, who is practicing in Delhi. So, he is continuously fighting for transparency in judiciary. So, let's ask him. So, what is your motto of transparency in judiciary? Why are you fighting for this?
Look here, judiciary is the only organization which appoint themselves. And when the judges appoint themselves, obviously that has led to the appointing their kith and kin. The juniors and kith and kin of their senior advocates, and those of the senior ministers in the government, governors, chief ministers, cabinet ministers, and therefore the pool of selection of the judges has come from a very narrow pool, and therefore it is entirely has become a synonym for nepotism, and it has also led to corruption. So what is the need of the hour is that the appointment system should be completely democratized. Like in we select IAS, IPS officers, etc. And the appointment in many tribunals also, there should be an open selection. The vacancies have to be notified. Okay. Applications have to be invited from all those eligible and desirous. Yes. And there should be a commission, there should be a forum which can select those who are find the best from that, and subject to certain rules to be made, and subject to certain in a transparent way. The job of the judge is to adjudicate dispute. Appointment of judge is not the job of the court at all, and the constitution did not provide that. Yeah. Constitution only provided that chief justice shall be consulted. Okay. So that there's a consultation does not mean consultation, it is concurrence, not even concurrence, the primacy. So they said they're saying that judiciary, independence of judiciary is a basic structure, and the core of the basic structure is in the appointment, and that core is protected when the opinion of the chief justice has the primacy, and the chief justice's opinion is not the opinion of the chief justice but the plurality of the judges, and the plurality of the judges' opinion has to be ascertained through a collegium. Therefore, that is how an unconstitutional body came into existence. And the Modi government in 2014, in continuation of the efforts of Congress government, brought NJAC, and the both houses of the parliament and 2/3 of the assemblies ratified the act and the constitutional amendment. And 4 judges acting on a PAL called SCORA, Supreme Court Advocate Record Association, that is under, that's all managed by a few lawyers. They wanted to retain the power with them, and certainly the judges also didn't want to allow the power to be lost. So it was a coup. It was a petition instituted at the instance of judges and certain lawyers, powerful, they run the show, and the whole hearing was a mockery. I was one of the petitioners opposing the Collegium System. And I asked them, if at all it has to be heard, then it has to be a bench where none of the judges would be part of the either part of the Collegium or will become part of the Collegium in future.
In your opinion, the Collegium system promotes nepotism, and Absolutely. It is the bone of contention.
No, I would say Collegium system is a synonym for nepotism and favoritism.
आप देख रहे हैं सौगंध टीवी, सौगंध वतन की।